Number 25. It's in the hearing column, my lord, of today's list, my lord. In fact, this matter is listed for fixed for today, but I have some difficulty today, my lord. So I've circulated an adjournment slip yesterday, my lord.
Item?
Item 25. It's a criminal appeal 42 of 2023. It's in the daily list, my lord.
Okay.
I'm for the appellant, my lord. If this can come up on the 31st of August, my lord, if possible.
All 31st of August, on the prayer of learned counsel. The appellant?
Appellant, my lord.
Yes.
Obliged, my lord.
May I seek your lordship indulgence in mentioning part 2, item number 32, lordship. I have taken the consent of the other parties if the matter can be kindly taken up on 1st of September.
First of September?
Yes, lordship.
Directed to be listed in the next hearing list. 32.
Yes, lordship.
30.
Item number 32.
Item number 32. On the prayer of learned counsel for the appellant.
Yes, lordship,
The
appellant.
matter is adjourned. Place the matter in the next hearing cause list, commencing from 24/8/26. Yes. After that, if you need a figure, separate date, then you mention it. It will come in the next hearing list.
Yes,
So if you want it to be done in a particular day, you make a mention then.
Yes, lordship. Deliberate.
I seek your lordship indulgence in mentioning part 2 hearing item number 16. Although this case was fixed on 18, due to my senior have some personal difficulties, so if this matter can be taken on this coming Tuesday, that is 25th of August.
So that will be also go to the next cause list.
Yes, your lordship.
Okay, same order.
Obliged, your lordship.
May it please your lordship. Lordship, I beg to mention item number 17 and 18 of the daily list. My lord, the arguing counsel, Mr. M. Bishwas, he is not available due to bereavement, my lord. Kindly fix another date, your lordship.
Item?
17 and 18 of the daily list.
All right. When do you want? When do you want?
26th August, your lordship. Next week.
26th of August.
Obliged, your lordship.
Admission item 1.
Hello, may I please lordship?
Yes.
Well, item 1 to 3 is a civil event petition against the order of the execution court, my lord. And here, item number 1 is concerned, my lord. The railway acquired land of the private respondent, my lord. My lord, the awarded amount, my lord, already this amount already, my lord, deposited in 2014-13 itself, my lord. In my this PS, my lord, is 43, my lord. We have paid the amount for PS 43, 44, my lord. The awarded amount already deposited and the certificate also issued, my lord. 43, my lord, certificate issued. The amount was already paid, my lord.
Deposited with the Deputy Commissioner.
Yes, my lord. And that was disbursed also, my lord. Therefore, what happened, my lord? The private respondent filed the application under section 28A. Because initially their land value was zero, there is not assessed the land value. So subsequently, a similar situated person they approached by filing under section 18 of the said act before reference court, and reference court, my lord, they fixed the land value, my lord. And this private respondents, they filed a petition under section 28A of the act, and the district collector sent this said petition before reference court. But reference court, your Honor, may please turn the order of the reference court. Reference court is the reference court. This relevant portion is 136. 136. Reference court remand back the said 28A, paragraph 6. I have heard the council so and so, but Your Honor,
Just a
your
moment,
Lordship is got-
just a moment, just hold on. In the brief I have before me, after page 90, it straight away goes to page 159. What is this?
136. 136.
I don't have 136. After page 90, next page is 159.
Yes, my Lord. Lordship, the page is something different. Maybe my Lordship, page 135. 135.
That is what I am telling you. Can't you hear me?
Understand. Filing paging may be mistake.
Page 136 comes in between 90 and 159. So from 90, next page is 159. Where do I find 136?
Sorry, my Lord, this.
List these matters again on Monday.
Item number 2.
All two, 1, 2, 3.
My Lord, no, 2 is okay, my Lord. 2 is okay, my Lord.
Item number 4.
My Lord, 2 is okay, my Lord. My Lord.
Yours may be okay, mine is not.
My Lord, Your Honor, maybe your Lordship may go through 2, item 2. 2 is okay, my.
Give two. Yes, where?
Here, the same though Your Honor, your Lordship, this we have paid the amount, and position page 36 is a certificate page 36. Page 36, the certificate whereby the land possession was given. Before that, page 35, 34 and 35, railway deposited the amount on 29/1/2014. Page 34, the awarded amount. And page 35 is the order of the district collector. And whereas the compensation amount same amount has been paid to the land owner of so and so. Now, therefore, the exercise of power the possession of land is located has been taken over on 1/7/2017. So amount was deposited, my Lord, this on 29/1/2014, and this page 34, and thereafter, my Lord, the possession certificate was given on 3rd July 2014. So the awarded amount is already payment was made. Thereafter, what happened? My Lord. There is a reference court order. Reference court order. Initially land value was 0. Subsequently, it was assessed. This space 89 from relevant portion start. 89. Last paragraph, hence the applicant are entitled to pay compensation for market value of their land at the rate of 25 per square feet solicium and 12 interest under section so and so. Also the interest under section 28 and 34 of the Act. My lord, what happened, my lord? We had the railway paid the interest under section 28. 28 was paid after after reference court order. This is page 38. We have paid the amount. The page 38 we have paid the amount. We have paid the calculating under section 28. We have paid the amount. The page 38 is railways paid. So reference court order was 2nd May 2019. We have paid 2nd September 2021. There is delay in payment of the reference court payment, but the awarded amount which was paid initially, it was before taking possession. We have payment was made. So therefore, what happened, my lord? The next page 93. Page 93, another assessment was sent. This page 93, the 13th December 2021. This is relating 34 section 34 of interest of LA. Here the assessment was made. The next page, next page. It is page 94. The interest was counted from the date of possession till the payment from the date of possession 3/7/2000 extremely right 3/7/2004 to 3/7/2005. Thereafter 15% 4/7/2015 date of making assessment by DC. So up to the DC assessment, it was made. So in this case, we filed a writ petition before this honorable court, challenging the assessment of the DC. This your lordship may turn page 110 of the order of the honorable court. Here in the relevant portion is page 103. In the interim operation of impugn or letter dated of assessment number 13/12/2021 shall remain still until further order. That means this letter, I have shown your lordship on page 93. My lord, what happened? There is an execution case is going on, my lord. It is fixed today itself before the district scholarship, district judge scholarship.
No, that is that 103. That is an order staying the communication of the deputy commissioner.
Yes, my lord. This is the assessment. This is my assessment, my lord. Page 93, my lord. Pursuant to order of first text so and so in connection of, I am sending the calculation of 34 in respect of so and so. You are requested to deposit this so and so, the amount. The amount is 19,59,000 so and so. So that was stated by the honorable court, my lord. But here what happened? There is my lord, the execution case is pending, my lord, before the district judge scholarship, my lord. Page 95, my lord.
What is the order that you are challenging now?
Yes, my lord. This thereafter, my lord, we have submitted the order of the honorable High Court before the district judge, my lord.
You are challenging you are challenging the order of execution.
Yes, my lord. Yes, my lord.
23/7/26.
Yes, my lord, and as well as the execution proceeding, my lord. This we have in page 99, my lord. We have submitted the order of the district honorable High Court, my lord, before the district judge scholarship, my lord. But in turn, my lord, it was not considered, my lord. We have annexed the order of the High Court, my lord. On page 99, my lord, a copy of the order so and so of the High Court is annexed, my lord. So thereafter, what happened, my lord? The learned district judge passed an order, and that is, my lord, this order relevant portion start from 105, my lord. Without considering the order of the High Court order, and page my lord 106, my lord, the last line on 20 today, my lord, 28 2020, the order for attachment of the assessed property belonging to NR is so and so, my lord. So it is supposed to pass an order for attachment of the property, my lord. So our case is, my lord, is from the date immediately, my lord, we have awarded amount is already paid, my lord. So from the date of possession, this section 34 does not arise, my lord. This section 34 is only arise from the date of reference court or reference court, my lord. This reference court order was passed on 2nd May 2019. We have paid the amount thereafter, my lord. So we have paid the amount, my lord, on 2/9/2021, my lord. That 34, this interest they will be entitled, my lord. As per section 34 of the Act, my lord, I am reading, my lord. This section 34. The payment of interest when the amount of such compensation is not paid or deposited, or before taking possession of the land, collector shall pay the amount awarded with interest thereon at the rate of so and so. So this was, my lord, this initial payment of the awarded amount already paid, my lord, in 2014 itself, my lord. Now they calculated calculated, my lord, from the date of possession, but that is not permissible, my lord. So this honorable High Court, my lord, in WPC number 61 2026, my lord, pass an order, my lord, where it is, my lord, in paragraph 3. In contented learned counsel for a petitioner that instant land bill of 0 at the time of determination of compensation under section so and so, statutory relating to the payment of interest 34 is not attracted. Accordingly, it is submitted that the assessment order granting so and 34 from the date of compensation is without authority law. It has been brought the notice that this court similar to issue is pending from the division bench of the Gauhati High Court. Same issue is pending before the principal bench, my lord, in the writ appeal 265 to 320 cents, my lord. So that led assessment which was sent, my lord, that was there. So, my lord, my lord, my question is the execution court only to execute the assessment made by the DC, my lord. DC, that was already stated by this honorable court, my lord. So execution court, that was not considered. We have informed that why we have the petition before them, the execution court, my lord. That was not considered, and today is date fixed for, my lord, the attachment of the property of the NF Railway, my lord. So at this stage, my prayer before this honorable court, my lord, is because this assessment has to become as per law, my lord, section 34, my lord, from the date of, my lord, delay payment, my lord, not from the date of possession, my lord. So execution proceeding as well as, my lord, this order passed by the honorable learned, my lord, district scholarship may be stayed, my lord. This is my humble prayer.
The original case was LA case number 1 of 18.
Yes, my lord.
So this execution is in respect of that order.
Yes, my lord. That orders I have already shown. It is already enclosed, my lord. This relevant
Yes,
portion
2nd
starts
of May
from-
2019.
Yes, my lord.
So what has happened to this order? Has it not attained finality?
This was, my lord, this was the last portion of the order, page 90, my lord. Last page 90, according to district collector shall reassess the compensation payable to the applicant by a supplementary award, including the value of the applicant's land. Value of the land already it was given, my lord, this which is to be calculated at the rate of so and so, and also interest on 28 and 34 as per Land Acquisition Act. Within period 2 months from so and so. So, my lord, we have, my lord, they paid, my lord, under section 28 interest, my lord, from as per this order, my lord. This was, my lord, this I have already mentioned, my lord, page 38, my lord. Page 38, this is the amount, my lord, we have already paid. We are also agreed to pay section 34 interest also, my lord, from the date of, my lord, the delay payment of the reference court order, my lord. Before that, there is no land value, my lord, and this already we have paid the compensation amount in 2014 itself. Before take position was taken, my lord. So here 28 is already paid, my lord, in this paragraph 38, page 38, my lord. So that amount is already paid, my lord. Only we are, my lord, the calculation part, my lord. We have challenged before in writ petition, my lord. Calculation part has to be from the date of passing the reference court order, my lord, not from the date of, my lord, position, my lord.
So pursuant to that order of the district judge, the district collector has issued this page 93 communication.
Yes, my lord, yes, my lord, pursuant
For
to the
assessing the figure at 1959,318.
My lord, 1959, this was, my lord, calculated from the date of position, my lord.
Yes.
The
Now
calculation is, my lord,
that was challenged in this writ petition.
Yes, my lord. That was state, my lord. We are this, my lord,
So
from the date of position.
because of this calculation itself has been stayed, therefore the execution cannot proceed. That is your case.
Yes, my lord. Yes, this is the case, my lord. Because with this has to, the lordship may turn pays, my lord. This execution petition lordship may turn, my lord. Execution petition page 96, my lord. Relief paid, my lord. Relief paid. Last 12, my lord. Serial 12.
Yes.
That amount, my lord, 19 lakhs 59,361, my lord. That amount, my lord. That amount, my lord, this pays, my lord, 93 also, my lord. State by this Honorable High Court, my lord.
Yes, anybody for Deputy Commissioner? No.
Yes, Your Lordship. If notice may be issued, Your Lordship, this is the first time it is listed.
Today is the date fixed by Scholarship, my lord, for that order, my lord. So, Lordship, may please to, my lord.
Since the calculation on the basis of which the execution court is proceeding has
Yes.
been stayed by the High Court.
Yes. And
What is
moreover,
the-
Your Lordship, this present case, the interest of the private party is affected. So if notice be issued to them as well.
No, but if we allow the execution to proceed, then what will be the result ultimately?
Yes, if the execution process,
This is the issue pending before principal bench, my lord. If this, whether this is the date of person or from the date of reference court order, my lord. So it is already fixed on 12th of November, my lord, before the principal. And
Heard Mr. S.K. Medhi, learned counsel appearing for the petitioner, also heard so learned government advocate appearing for 1 and 2.
Yes, Your Lordship.
1 and 2. By way of this petition, the challenge has been made to the execution proceedings in execution petition number 18 of 2025 arising out of LA case number 1 of 2018. Full stop. Further, by the impugned order dated 23/7/2026, passed by the learned additional district and session judge scholarship in the aforesaid execution case, the where is that order? Execution order?
execution order, my lord, the last my lord, 100 and my lord, 4, my lord, 4, 5, 6.
The executing court is proceeding to attach the assets of the NFR, and the date of attachment has been fixed on 20/08/2026, that is today. Para learned counsel for the petitioner has drawn the attention of the court to the order dated 19/5/26 passed by this court in WPC number 61 of 2026, whereby the operation of the letter of assessment dated 13/12/2021 has been stayed until further orders. Where it is the submission of learned counsel that pursuant to the order of the reference court, the district collector has calculated the interest component under section 34 of the so and so act at rupees 1959
318, my lord.
and according to learned counsel, the said assessment itself, as contained in the aforesaid assessment letter of assessment dated 13/12/2021, having been stayed as above, the execution proceedings also cannot be allowed to continue. It is further submitted that the issue as to the date from which the interest is to be paid is in question, is it?
My lord, as per this, my lord, from the date of reference court, my lord, not from the date of possession, my lord.
That is what? That is under consideration before the division bench. As the date from which it is to be paid, is it not?
from which already, from the date of person, from the subsequent, my lord, reference court order, my lord. Reference court order, my lord, because we have paid all the amount, my lord, earlier.
No,
my
no,
lord.
that
So
is
now
not
they-
my question. The issue before the division bench, whether these writ appeals are pending,
Yes, my lord.
that is regarding the date from which the interest is to be paid.
Yes, my lord.
Yes.
From
Yes.
which date, my lord? Whether from the date of person or from subsequent?
The issue as to the date from which the interest component is to be paid is under consideration in a batch of writ appeals, being WA number 265 of 2023, WA 320 of 2023, and WA 8 of 2024. Full stop. Wherein there has been stay of orders passed by the district collector along with the impugned order of the learned single judge against which the writ appeals have been filed. Full stop. Issue notice returnable in 4 weeks. Give a date.
16, my lord, September, my lord.
All right. Notice is accepted on behalf of respondents number 1 and 2 by Ms. So-and-so learned government advocate. Extra copies be furnished within 3 days. Steps in respect of the remaining respondents shall be taken by speed post with AD within the next 3 working days from today. In the interim, the operation of the impugned order dated 23/7/2026 passed by the learned additional district and session judge Kolasid in execution petition number 18 of 2025, as well as further proceedings in the said execution case shall remain stayed until further orders. List again on
16 minutes.
16 September.
Oblige.
My lord, item number 3 also, my lord, the same, my lord.
So we pass the same order.
Same order, my lord. Only, my lord, date may be different, my lord. And next order, PS 99, my lord, the 34, my lord. PS 34, my lord, is, my lord. PS 99, my lord, 99. This is the assessment made by the DC, my lord.
Okay.
And my lord, the execution case is, my lord, PS.
Okay, page district collector's letter dated 14/1/2022. Okay, in item 3.
Execution case, my lord, PS 127.
Yes, execution case number is 120.
My lord, 17 of 2025. 17 of 2025, PS 127, my lord.
Execution case number will be 17 of 2025.
In
Where
LA case
is
number
the next
6 of
date fixed in this case?
Same, my lord, same, my lord. All are
Same.
same, my lord.
All same.
Yes, my lord.
All right.
And High Court order is, my lord, PS 132, my lord.
So this is also same.
Same, my lord.
Same writ petition or different?
Different petition, my lord.
This is writ petition 55 of 2026. Order date is
Well,
7th.
right.
Yes. And one was also same.
Yes, my lord. One is, my lord, order dated, my lord, 14 January 2022,
Okay,
my
item
lord.
1, order dated 14.
14/1. This is, my lord, this is letter, my lord.
This is
14/1
letter.
2022.
District collector's letter is dated in item 1.
14 January 2022, my lord.
14 January 2022. Okay.
And my Lord, execution case is 19 of 2025, my Lord.
Execution case number is 19 of 20
2025, my Lord.
25.
And LA case number, my Lord, 1 of 2019, my Lord.
LA case 1 of 2019. You check from the cost titles, okay? Typing.
And my Lord, the High Court order is, my Lord. High Court order is, my Lord.
WPC.
It was, my page 165, my Lord. Interim order is continued on last 14 also, my Lord.
High Court order is in writ petition what?
Writ petition, my Lord, writ petition order is, the date, my Lord, 28/4/2026, my Lord.
28/4/26 in WPC number
31/2026, my Lord.
31 of 26.
And my Lord, this, my Lord, the execution case order, my Lord, same date, my Lord.
All right. Rest
Same
is
date,
him.
it is date is my Lord, 23rd July 2026, my Lord, is order. And today is the fixed, my Lord.
All right. Date of order of executing court is dated 23/7/2026,
23/7/2026, my Lord.
23/7/2026. Yes.
And my Lord,
That
this
is same, I
today
think.
is
This is the
same,
that is
man.
same, I think, in the as the other cases.
yes, my Lord, same day, same order, my Lord, and that is fixed today itself.
Rest will be same. Yes.
My Lord, only, my Lord, the notice may be go, my Lord, from private respondent, my Lord, is 1 and 2, my Lord, the state of Mizoram, my Lord, and district collector, my Lord, and from 3 to, my Lord, 3 to, my Lord,
All are private respondents from 3.
3 to 122 private respondent, my Lord.
All right. We have issued notice to them. You have to take
My Lord,
steps
in
by
this
step.
case, paper publication may be allowed, my Lord, because so many this respondent is there, my Lord. This case, my Lord.
So, how many? 22.
Yes, 122, my Lord.
Is it permissible on the first day itself?
Next day, my Lord, I'll pray, my Lord.
Let notice
take
may
this.
be issued first, and
Same
if that
okay.
cannot be completed, and later on, the newspaper publication can be done.
Highly obliged, my Lord. On 16, my Lord, all cases 16/9, my Lord.
Yes.
Highly obliged.
Item number 4.
May I please, Your Honor, this instance is filed by the 8th Lanzama, that is the proprietor, Eastern Electrical Zargot Aizol, against the impunity penalty order under section 73(1) of GST and against the impunity rejection of appeal petition dated 29/7/2025 and restriction over the bank current bank account and the Axis Bank on dated 30/6/2026, Lordship. Lordship, the impunity penalty order was Annexure 114, Lordship, page 174, Lordship. Lordship, 9/7 here.
This is state GST.
Yes, GST, against the GST. Lordship, may I read this 9/7, that is, imposed applicable penalty on the amount as mentioned in para 9(2), 9(3) and 9(4). That is, in terms of 22122 of the GST Act 1917, read with section 73 of the GST 1917.
So where is the notice?
2017, Lordship, that is. Page 174, Lordship. Page 74, bottom, that is the impunity order, Lordship. (174), Lordship. Page 174. 92 to 97, Lordship. That is, I order for the recovery of the short paid GST liability for the period of 2019 to 2020 for the tax period 2019-2020, Lordship. And thereafter, Lordship, we have submitted appeals against the impinge penalty order. Lordship, that is also rejected without considering any merit of the case, just on the ground of technicality that it has been submitted. They have the power to attachment, Lordship, for a period of only 1 year, Lordship.
You were given opportunity. You did not appear. 171, para 7. Notice failed to reply within the stipulated time, however, given opportunity on different occasions, 21/6, 3/7, 11/7, but notice failed to appear in any of the scheduled dates. Why did you not appear?
Lordship, actually, that is that his file was pending with this accountant, Lordship. That's why he could not appear, Lordship.
Where is the accountant there for? He is there for this purpose, to satisfy the tax authorities. You can say he is pending in the.
And Lordship, this her daughter is studying in abroad, Lordship. Only with this CD account they used to send him money. It is pending. So, Lordship, at least at interim, Lordship, we pray that this petitioner may be allowed to utilize his CD account, Lordship, at Axis Bank, because there is.
What has happened to the account? It has been frozen.
It is not frozen, Lordship. Only they say that it is restricted by way of lien. So they have no provisions. There is no provision. They have only provision is section 83 of the GST 1917, Lordship. May I go to Lordship with this?
Yes.
This provisional attachment to to protect revenue in certain cases, where during the pendency of any proceeding under section 62, 63, 64, 67, 73 and 74, the commissioner is in opinion that for the purpose of protecting the interests of the government revenue, it is necessary so to do, he may, by order in writing, attach provisionally any property including bank account belonging to the taxable person in a such manner as may be prescribed. Every such provisional attachment shall be ceased to have effect after the expiry of 1 year from the date of the order. Lordship, they have no any power, Lordship, to restrict the operation of my bank account by way of lien. They have only the provisions is 83, Lordship. They cannot go beyond this 83. It is not under 83. They have restricted. That is ultra virus, Lordship. They have acted upon beyond their power.
Of which act? Which GST Act?
GST Act. Yes.
GST Act.
Yes. They have no any power to restrict operation of my account, except with section 83, Lordship. They have not applied in this case section 83. So I am in a great problem that my daughter is studying in abroad. I cannot send money, Lordship. So it is my humble prayer, Lordship, at least to allow me to operate this my account and during the pendency of this writ petition, Lordship. Moreover, Lordship, the appellate authority also the same department. It is biased. Without any merit, they have decided and rejected my appeal application, Lordship. So, maybe please to issue notice and decide the matter on merit, Lordship. That is my humble prayer, and to allow me to operate my CD account.
Who is appearing for state GST?
Yes, Your Lordship, I'm appearing for the state GST. However, Your Lordship, we are only the pro forma respondent. The main Respondent has to be the central GST, and the council is here.
Yes. This
Lordship.
is, no, his submission was this is relating to state GST, that is why I asked it.
Lordship, this is CGST. There is every...
Then say that
Yeah.
when I asked, is it state GST, don't just nod your head. Say
Yeah.
this is central GST.
This, Lordship, this under CGST, that is, share is 50-50, Lordship, both the
Yes.
state and the central.
Lordship, my objection at this stage is that there is a statutory alternate remedy available under the CGST Act, Your Lordship. So they have not exhausted that remedy. So the writ petition is maintainable at this stage. Because, Your Lordship, under 107 of the CGST Act, if they are aggrieved with the order in original passed by the department, they have to go for the appeal under 107 of the CGST Act. And again, if they still aggrieve, there is another provision which is 112 of the CGST Act. That is the appellate tribunal. That is under 112, they can file an appeal against the order passed by the appellate authority. And if they still agree with Your Lordship, they can approach this honorable court under 117 of the CGST Act on the ground of substantial questions of law. So they have not exhausted the alternate remedy. So this 227 is not, Lordship, is not able to invoke at this stage, Your Lordship. May not be allowed.
226.
226 is not allowed at this stage, Your Lordship. It's not maintainable. And I have some authority, Your Lordship, and
Yes, what is your response to that? He says this is not maintainable at all.
Lordship, as per Annexure 116, page 179, Lordship, we have submitted the appeal as per provisions of the section 113 and 115, Lordship. This is the order, summary of the demands after
Page?
the issue of the page 179, Lordship. This is the order of the appellate authority, Lordship. It is passed by the Additional Commissioner of Appeal, CGST, EX, Custom, Gauhati. We have already appealed, Lordship. It is rejected. Page 179, Lordship, Annexure 116.
So appeal is rejected.
Yes, Lordship. Merely on the ground of
That-
technical
that
there
appeal
is
is-
a,
oh,
there is a some delay only on without considering any merits in our submission, Lordship. So that is a bias and it is a punitive, Lordship. So
CGST, Lordship, yes.
So, Lordship, the interference of
Courtmaster,
Lordship is
CGST
highly warranted in this case, Lordship.
Central GST Act.
Annexure 116, page 179.
Please appellate authority and the one.
So this was page 179, this was before the appellate authority.
Yes, Lordship. And
So
appeal,
that was rejected.
appeal
So
appeal
then
number.
you can go again under 1112 before the appellate tribunal.
Lordship, yes, very true. Yes. If they still agree, then they can approach the appellate tribunal. In that appellate tribunal, there are 3 members. In that appellate authority, there is only 1 member, which is the commissioner or joint commissioner. So that was not exhausted by the petitioner here in Lordship.
And in case that goes against you, there is still 117.
Lordship, yes.
You have to approach the High Court by way of a statutory appeal. The 117.
Yes, Lordship.
But how is the writ petition maintainable then? This does not say whether it is dismissed for merit or whatever, or time barred. The section mentions nothing. It's against any order. Even if it is on a technicality or on ground of delay or whatever, the appeal is lies. Better you come back on another day after going through this and decide what to do.
Well, Lordship, at least.
Unless we are satisfied on the maintainability, so interim order is very difficult. You can list it on another day, you have a look and
Yes,
decide
sir.
on your course of action.
Yes, Lordship.
Because even for the appellate tribunal, he has already delayed by more than, I think, several months. That order is of 29/7/25. So October 2025, your timeline expired.
Lordship, yes.
There is any provision for condonation there?
It's, if I'm not wrong, there is a 3 months this
Ah.
delay. That is acceptable, 3 months.
No, 3 months is already provided by the statute. Whether there is
Possible.
any provision for condonation of the delay, does the Limitation Act apply? All right, on the prayer.
Lordship, that they have taken action again in continuation of that. They have action.
Whatever, but you have to get over this barrier first. Section 107, 112 and 117. So, heard learned counsel for the petitioner, learned standing counsel, Central GST,
Yes, Lordship, standing counsel.
raises objection with regard to the maintainability of the present writ petition in view of the statutory provisions for appeal contained in sections 107, 112 and 117 of the CGST Act. Full stop. On the prayer of learned counsel for the petitioner, lays the matter again on. Yes, when?
After 3 weeks, Lordship.
After 3 weeks, give a date.
That's fine.
Motion, item 5.
May I please, Your Lordship? Kindly see the last order, 11/8/2026, my Lord. In this case, the matter pertains to direction for considering the case of the petitioners for regularization into government service, who were primary teachers working under SSA.
What is the status now? Have all the
My Lord,
respondents entered appearance, filed affidavits? What is the
the respondent
position?
number 9 had recently filed this affidavit, and what I would like to submit is that there is no any further steps taken apart from which have been considered in the IA for extension. There is no development. There is no development at all, and they have enclosed one document, communication dated 23/2026, which pertains to recommendation in respect of special teachers, but not the petitioners. Meaning thereby there are no steps taken at all in respect of the petitioners in pursuant to the judgment order which I'm seeking to implement. This is a clear case of willful disobedience. And on the other hand, the state respondents have been taking active steps for making fresh recruitment, open advertisement, while ignoring the standing direction of this Honorable Court. It is for this reason that this Honorable Court in IA 28 of 2026 had dismissed their application for extension of time for compliance, since they have not taken any steps at all. We are seeking implementation of the judgment rendered on 17/3/2023. Even after a lapse of 3 years, my Lord, this is the present status. It appears that they have no intention at all to take any positive steps in pursuant to this judgment. During last year, they have recruited as many as 1,024 casual teachers without first considering the case of the petitioners. Now they have also taken steps for filling up as many as 312 posts through open advertisement. The members of the Petitioners Association had rendered 20 to 30 years of service in the same capacity. Now, some of them have already retired.
It appears some affidavits have been filed.
Yes, Your Lordship. If
Page number 322 onwards,
Your
the
Lordship,
latest affidavit.
The leading counsel has some personal problems. So
No, we are not going to consider all that. This, you are playing games with the order of the court.
Oh, Your Lordship, we have filed the affidavit, yes.
In the given running page, my Lord, this recent affidavit is numbered starting from 322.
This is a contempt of 23. You are taking us on a long ride.
Your Lordship, if I may contact the leading counsel and if she can...
Contact, but the last order is very clear. One
Yes.
last opportunity was granted. It is made clear that if affidavit is not filed within the time allowed, court would hear the matter on
Lordship,
the basis
we
of
have filed the
materials.
affidavit on
Evidence.
18/8/26.
18/8/26 we have filed.
Yes, Your Lordship.
You have that.
I have the copy, my Lord, but I have already go through the contents of the affidavit, and the fact remains that no steps have been taken in pursuant to the direction of this judgment.
Yes, then we proceed to hear. Yes, where is that affidavit?
Page number 322, in the reading page, pagination 322.
Your Lordship, if this matter may be passed over and listed at the last item, so I will contact the leading counsel so that she can appear through VC.
All right, call them. Let them come.
Obliged, Your Lordship.
Judgment. All right. Yeah. Call it up.
For delivery of judgment, item 1.
Appeal is dismissed.
Item number 2.
Yes, item number 2, who is there?
Yes, ma'am. Malo, here, malo, the earlier rejected by an option. No. Now, malo, upgrade diary and he is inside for around malo, the 69, 70 days. Malo. The first one, malo, no, malo, some altercation, then unfortunately he died, she died, malo. That case. Case 16 is the FM. Last page, my page 65, my lordships earlier, my lord, that
So
rejection.
this is a new motion, isn't it?
No, definitely, my up to date diary, my lord, possibly necessary.
Mm-hmm.
Possibly, my lord, lordship may call for the up to date diary.
Yes, yes. Heard
At that stage, 31/7 it was rejected last.
All right, this is item 2, Heard Learned Counsel for the petitioner. This is the second bail application in respect of the present petitioner. Call for the updated case diary. List the matter again on. It will be in Gauhati.
Lordship. Fine.
All right.
From Chanmai. Immediate lordships. Now 69 days. 3rd of September. Lordship.
2nd of,
3rd of September.
3rd of September. All right.
Much of it.
Item number 3.
Wait, please, Lordship. Second bail application, my lord. Till today, my lord, 60 days is completed, my lord. Statutory period
What is the offense?
The offense is not under section 302, 303, subclause 2, 317, subclause 2, 304, etc. My lord, stolen the 11 numbers of cows. One
Yes.
cow is recovered.
CS
under
not
the
submitted as yet, PP.
Not submitted. Not submitted.
So today is 60 days
Till today, my lord, 60 days.
from date of production.
It's from the date of 22/6.
Calculate the date.
My lord, June 9 days, July 31 days, August till today, my lord, 20 days, my lord. He all tell my lord 60.
They can still file it today. Is it not?
Till today.
All right, go to page 21. Para 1, para 2, then para 3, an earlier bail application. In respect of the present petitioner being bail application number 1936 of 2026 was dismissed by this court by order dated 11/08/2026. Full stop. Para the instant application has been preferred, seeking bail having regard to the fact of detention of the petitioner for 60 days as of today. Then para 3, para having regard to the period of detention of 60 days and the fact that the charge sheet has not yet been filed, and the statutory period of detention will also expire today itself, the prayer for bail is allowed. Petitioner so and so shall be released on bail of rupees 50,000 at 2 sureties of like amount to the satisfaction of the which court?
SDGM Bilashivara.
Huh?
SDGM Bilashivara.
SDJM Bilasipara.
M. SDGM Bilashivara M.
M. Huh? S.
M.
M. It is further provided that the petitioner shall not hamper the investigation and shall cooperate with the remaining investigation. Full stop. Petition stands allowed accordingly.
Develop.
Item number 6.
May I please, Your Lordship? Lordship, as per the last court's order, the respondent number 1 is allowed to file an affidavit without fail.
Lordship, I'm for respondent number 1 on behalf of my senior, Mr. Miller. If I may be given 2 weeks' time to file our affidavit in opposition.
Who are you?
I'm for respondent number 1. ma'am.
1. State.
No, private.
Achha. Oh, you're the private respondent.
Yes, ma'am.
There are state respondents. What is the matter about?
The matter is that, Lordship, we have filed this revision petition for setting aside and quashing the order dated 3rd of July 2005 passed in CMA, in which the learned trial court has allowed the amendment of plaint of civil suit number 30 of 2022 after an expiry of 1,197 days, Lordship. That is almost after 3.5 years after filing the civil suit.
So you are the private respondent. How could you take so much time for filing an affidavit?
Now, if I may be given just one more chance, madam. If I may be given just one more chance.
One more chance, but not 2 weeks. Only in 1 week you have to file.
This, my lord, if possible, 2 weeks.
That is what we are saying. We are having regard to the fact that you have been given more than enough time. Third learned counsel for the petitioner and learned counsel representing the respondents. Learned counsel for the respondent number one has sought further time to file affidavit. It appears from the order sheet that sufficient time has been granted to the respondent number one to file the affidavit. However, one last chance is given to the respondent number one to file the affidavit within the next. Today is
28, my lord.
by 31/8/26. Place the matter again on 31/8/26.
Lords, my presence could be marked also. Legally, it counts for R2 minutes.
All right, Mr. So-and-so appears for respondent number 2.
You be obliged.
Item 7 and 8.
Yes, may I please, Your Lordship? I'm for the respondent number 4, a complainant. May I seek 2 weeks time for filing counter affidavit for 2 items. And for item 7 and 8, yes.
No records have been called for so far.
No. Oh, my lord.
Not yet, my lord, yes.
This is what, challenging the FIR?
Yes, my lord, quashing of FIR.
All right, heard learned counsel for the petitioner and learned additional PP also heard learned counsel for respondent number 4.
4.
Who seeks time to file an affidavit. Okay. Accordingly, list the matter again on 4 weeks.
Yes, 4 weeks.
Interim order passed earlier shall continue till the next returnable date.
Obliged.
Obliged, Your Lordship.
This criminal petition 14 is also same in respect of same FIR.
Yes, my lord.
Yes, same here.
Same FIR.
You appear there also?
Yes.
Same order in both this.
Item number 9.
Respondent 3 and 4, anybody appearing? No.
It seems that no one is appearing, Lordship. Though.
Yes. Lordship, service report from respondent number 3 and 4 is still awaited. It is not yet completed.
Some report was also supposed to be filed.
Yes, Lordship.
As per last order, special PP Mizoram shall obtain instructions as to whether the respondents are going to file their final report.
Lordship, I'm representing the Union of India, not Mizoram. It should be
Okay.
It's a mistake. Lordship, I may be given another 3 weeks' time to obtain instruction. I've already communicated, but I have not
Heard
received the
learned
instruction.
counsel for the petitioner and learned. Your special PP.
Lordship, yes.
Special PP, Union of
Union
India.
of India, Lordship.
Union of India. Service on respondents number 3 and 4 not yet complete. Learned special PP also 6 for the time to abstain instructions. List the matter again on after 3 weeks. Give a date.
Item number 10.
I have taken steps against the respondent number 2 by way of justice. The service is completed. File the affidavit also.
Already heard learned counsel for the appellant. It is submitted that service on respondent number 2 has been effected by way of justice service, and affidavit in this regard has also been submitted from peruse the same. Full stop. Accordingly, service on respondent number 2. Somebody is appearing.
I'm appearing on behalf of respondent number 1.
Okay. 2 is deemed to be complete. Mr. So-and-so appears for respondent number 1. So have it for admission.
Yes, fine.
List the matter for admission on give a date.
Right, madam.
Item 11.
Yes, may it please your lordship. Your lordship, this is a contempt petition arising out of writ appeal, and the respondent has filed as LP before the Supreme Court, which was dismissed. And in the last court date, it is submitted that review has been filed again. Now, this review petition has also been dismissed by the Supreme Court. So I would like to place the order of dismissal before your lordships today. So now, my lord, the only course available for the respondent, as it seems, is paying the compensation which the petitioner is entitled.
So any affidavit filed?
My lord, after dismissal of the review petition, my lord, we have to obtain instruction afresh. I am for respondent number 1.
I'm appearing for the respondent number 3 and 4, my lord. I would like to seek some time to file proposed reply in respect of respondent number 3 and 4.
On behalf of my senior Miss Mary L. Kiente, who is representing respondent number 4, maybe 2 weeks' time may be granted to file a short affidavit.
Who is for 2? Respondent 2, you are
My
for
lord,
2.
2 is the chairman and managing director.
Huh?
I have no instructions with regard to 2. I have instructions and submitted Vakaranama for 3 and 4. And regard to 3 also, he is transferred to some other post and he has been replaced by his incumbent.
So you have not filed power for 2, only received instructions.
Only for 3 and 4,
Not 2.
not 2.
2, nobody is there.
Till now, no instructions.
Yes. And your lordship, as per my information received, respondent number 2, there is a new incumbent. So in the meantime, if I may be allowed to file implement application.
In respect of 3 also, my lord, he has been transferred to other location. He has been replaced by someone else.
So heard learned counsel for the petitioner. You will go to order dated. This last order, first para. All this counsel is there. Okay, it is submitted that. Who is transferred? 2 is transferred.
2 is no longer in his post, and
That
3
is-
is transferred and replaced by someone else.
2 is no longer in his post means he is gone now.
He has retired.
Upstairs. Huh?
He has retired.
Retired.
And your lordship, there's a new incumbent.
New incumbent.
It is submitted that respondent number 2 has retired and respondent number 3 has been transferred.
3 has been transferred.
Learned counsel submits that she will be filing applications for implement of the new incumbents para. It is also submitted that SLP number 127 of 2026 preferred by NPCC was dismissed by the apex court, and subsequently the review petition has also been dismissed by order dated 14/7/2026, copy of which has been furnished. Keep the same on record. Full stop. The respondents who are already represented are directed to file their affidavits within 2 weeks, detailing the steps taken for compliance with the judgment of this court. Full stop. In the meantime, appropriate applications may be filed by the petitioner for implement of new incumbents after serving copies of the order to the said incumbents. You serve copy to the new incumbents.
Yes.
Please the matter again after 2 weeks. Give a date.
Item number 12.
May I please, your lordship. My lord, on the last occasion, the respondent number 2, the chief engineer of the BRTF, is newly implemented, and notice is yet to be issued in respect of respondent number 2.
Lord Learned Counsel for the petitioner. Also heard so and so for respondent number 3. Who is somebody is appearing for 5? Last date means B. Lalrem Nemi. Not there. For respondent number 5, someone had appeared. B. Lalram Nemi.
This is my junior petitioner side. Bilaram name is on
It
petitioner
says
side.
press for time to file application for for application of implement. You have filed. For implement of respondent number 5.
My lord, in pursuant to this, we have filed an application for implement, seeking implement of the proposed incumbent as respondent number 5. But this honorable court, while disposing the IA, instead of placing as respondent number 5, has replaced the existing respondent number 2.
So out of the who is 1? Anybody has appeared for 1?
I'm for respondent number 1.
Heard
Secretary.
Mr. Rolte Learned Counsel for the petitioners. Miss so and so appears for respondent number 1 and only 1.
Only 1 this time.
Okay. Then somebody is for 3. You were there. Okay. Yes, for respondent number 3. And what has happened to 2? Transferred.
The previous one was retired, has retired, and the present respondent number 2, every hearing is recently implemented and notice is yet to be issued.
No, the earlier respondent number 2 will be still be there even if he is transferred, is he not?
I understand that, my lord.
Yes.
In my IA application for implement of the present incumbent, I had proposed to implement as respondent number 5.
Yes.
But this honorable court, while disposing the implement application, instead of arraying as respondent 5, the existing respondent number 2 was replaced, has been replaced.
Where is the order?
The order is in IA number 119 of 2026. Order dated 19/6/2026 in IA number 119/2026.
By order dated 19/6/2026 in IA civil so and so, okay, 119M of 26. Dr. Krasnendra Singh, you look at the IA, was implemented as respondent number 2. Although he ought to have been implemented as respondent number 5. Accordingly, the said Dr. Krasnendra Singh, Chief Engineer, BRTF, Project Puspak, GREF, is implemented as respondent number 5. cause title be corrected accordingly. Para issue notice to the newly implemented respondent number 5. None appears for respondent number 2.
Lordship,
You are appearing.
I'm appearing on behalf of respondent number 4.
So and so appears for respondent number 4. You give it earlier, okay. 2, so the earlier 2 nobody is appearing.
Not yet.
None appears for. Is notice complete? Had you taken steps on the earlier one?
I have taken steps, my lord. As per the office order dated 29/1/2026, the service of notice upon the respondent number 2 has already been completed. It's recorded on order dated 29/1.
So we say nothing about respondent number 2 now, although he is still very much there. Place the matter again on. Yes, we did. 4 weeks.
Let it be 2 weeks, my lord.
What steps you have to take?
I'll have to amend the post title, and thereafter, my lord, notice has been issued.
All right. 2 weeks.
Much
Item
obliged.
number 13.
May I please, your lordship? Lordship, as per the office note, steps upon the respondent number 9 is still awaited. 9 is the DC, my lord.
You are appearing for?
2 to 8, my lord. I have filed my power.
For?
2 to 8.
2 to 8.
Yes, ma'am.
What about 1? 1 is?
1 is the
Respondent
chief
number
secretary, ma'am. 9 is the DC Lunglei.
Heard learned counsel for the petitioner. Mr. So-and-so appears for respondent number 2 to 8. You will file the affidavit?
I will be filing within 2 weeks, my lord. Show
And
cause
praise for
reply.
2 weeks time to file affidavit. Notice on respondent number, ID card in respect of respondent number 1 has also been received back, but none appears. Place the matter again on.
Give me a flash.
Item 14.
May it please your lordship, my lord, I am for the petitioner. WO by the respondent has been received. TCR has been called and the same has been received. My lord, if paper book may be prepared.
So all are represented now.
Yes.
All heard learned counsel for the petitioner. All the respondents are represented. Only one respondent is there, it seems.
Yes, my lord.
Huh?
Yes, my lord. Sole responding.
Respondent so and so is represented. You have filed affidavit also.
Yes, my lord.
Affidavit has also been filed on behalf of the respondent. What was your submission paper book? Huh?
Yes. Yes, my lord.
So you are only against the order condoning the delay.
Yes, my lord.
So why paper book is required for that? We are not going through any evidence and all that.
My lord, the leading counsel is on his leg. If appropriate, date may be fixed for hearing.
Scanned copy of the TCR. Is it there? It is 14, is it? Huh? Scanned copy of TCR is also available. Hence, this is the matter for admission again on.
Item number 15.
Yes, please, Your Lordship. Lordship, we have filed this criminal appeal challenging the impugned judgment dated 17/6/2026 and its sentence order 23/6/2026. Lordship, the appellant herein was convicted under section 21C and was sentenced to undergo rigorous imprisonment for 10 years. Lordship.
All right, hard.
Do-
Learned additional PP. This appeal is directed against the judgment and order so and so. See from the custodian. Appeal is admitted. You have got copy?
Yes, Your Lordship. I have received the appeal memo, but however, paper book is not yet received.
Copy of
first time
memo
it's the
of appeal
understanding.
has already been furnished to learned edition and PP. Appeal is admitted. Call for the TCR. List again. Rich.
Orders, item 16.
Please, Your Lordship. My Lord, in this matter, the TCR which was called for, it has not come. My Lord, kindly fix another date.
Third learned counsel for the petitioner in addition and PP. TCR is called for has not been received. Issue reminder. List again.
My Lord, after 2 weeks. Your Lordship, today I had mentioned 2 matters on morning. My Lord, I had told the court that the next date would be 20 or 26th of August. But I had come to know that 26th August is a holiday here. Can it be on 25th, Your Lordship? Item 17 and 18.
25th.
25th of August. Authorized, Your Lordship.
Item number 19.
May it please your Lordship. My Lord, this bail application has come up for the 3rd time. I believe today the learned BP
Yes,
has
Your
sought.
Lordship, this case is handled by Miss Mary and she will be available on Tuesday. So if this matter may be fixed on Tuesday, next Tuesday.
This is the 2nd time they had sought for an adjournment, my Lord. And if your Lordship allows their adjournment, then perhaps at least on the next date we shall, if we may, attempt to dispose of the matter. Because I believe your Lordship is aware
Record
of
is the
the
case diary is available.
case diary is available, yes.
Third learned counsel for the petitioner. Who is handling?
Miss Mary can.
Submitted that Miss Mary learned petitioner PP is conducting this case in for the prosecution, and due to personal difficulty, prayer has been made for adjournment today. Place the matter again on Tuesday.
Deeply obliged.
Item 20.
May it please your Lordship. It seems the ID card hasn't yet returned.
Pardon?
I believe the ID card has not yet been returned. So, your Lordship, I respectfully requested the matter may be kindly be kept for a short day to await for the ID card.
Already. ID card in respect of sole respondent not yet received back, hence await service. List again on short bit.
Item number 21.
Lordship, as permitted by this honorable court, filed order dated 25/6/2026. I have taken steps upon the respondents number 2 and 3 by way of DASI service, and I have filed the affidavit to that effect, Lordship. So
Third learned counsel for the applicant and learned counsel for respondent number 1. Petitioner has effected dusty service on respondents number 2 and 3 and filed affidavit of service in this regard. However, none appears for respondents number 2 and 3. What is the IA for?
This IA is for the condonation of delay 46 days only, Your Lordship. And I have formulated the reasons of that such delay.
Yes.
Lordship, I'll be filing my objection for this condonation. Lordship, I'll be needing some more time.
This is MSc appeal.
MS, yes, Lordship, make appeal.
Take the
Who is the respondent number 1 PP?
Respondent number 1, I'm representing, my lord.
No, who is the respondent number 1?
Claimant.
Huh?
Claimant of before the MSCT. Is the awardee, my lord. He has been awarded almost 6 lakhs.
Some additional PP has put in appearance for respondent number 1. What is that?
You know.
Also, it seems that it is wrongly reflected. It's not additional PP, it's a private counsel.
Yes. Right. On the prayer of learned counsel for respondent number 1 seeking time to file objection, release the matter again on 2 weeks.
Item number 22.
Obliged.
If I may please, Your Lordship. My Lord, we have submitted a representation for respondent 2. We are yet to file a written objection. If 2 weeks' time may be given.
It heard learned counsel for the petitioner. Respondents number 1, 2, and 4 are also represented. AD card duly signed AD card in respect of respondent number 3 has been received back, but none appears. Objection has already been filed on behalf of respondents number 1 and 4. Learned counsel for respondent number 2, 6. Time to file objection. Accordingly, is the matter again on. Give a date after 2 weeks is
Item number 23.
May it please your Lordship, this is an application under Section 5 of the Limitation Act for condonation of 31 days delay in filing the connected criminal appeal against the impugned judgment order dated 14/5/2026 passed by the Fast Track Court. Policy.
any objection?
My lord, for 30 days, I will not have any objection. Let it be condoned.
Part learned counsel for the petitioner and learned additional PP representing the respondents number 1 and 2. This IA has been preferred seeking condonation of delay of 31 days in preparing the connected criminal appeal against the impugned judgment and order dated 14/5/26 passed by so and so. The regions hard learned counsel for the applicant and learned additional PP. The reasons for the delay has been explained at paragraph 3 of the instant IA, which I have perused. 3 and 4. Learned additional PP submits that she has no objection to condonation of the delay of 31 days. Full stop. Para having regard to the above. I am satisfied that the petitioner was prevented by significant cause from approaching the court, from preferring the appeal within the period of limitation. Accordingly, the delay stands condoned. I stands allowed.
Deeply obliged.
Item number 24.
Lordship, this is an application for grant of bail in connection with Section 21B of the NPS Act.
The hard learned counsel for the petitioner and learned additional PP. Call for the CD list again on
My lord, TCR.
TCR. Okay. Call for the scanned copy of the TCR along with CD list again on. When?
Next week, Tuesday.
Tuesday.
Obliged, Your Lordship. Item number 25.
Your Lordship, this case has been already mentioned this morning.
25. Where is 25? I'm getting 25. Yes, this is already mentioned.
Item number 26.
I seek your lordship indulgence in allowing me to file additional affidavit so that the query posed by this honorable court may be addressed.
All right. Learned counsel for the petitioner prays for some time to file an additional affidavit.
In respect of IA 31 of 25.
31.
Yes, my lord. There is an order of direction of the Mizoram Lokoikta to file a charge sheet.
Prayer is allowed. List the matter again on.
16 September.
Now,
by that time, they will file their written objection.
in the meantime, respondent may file its written objection.
Lordship, on the 17th,
17th, I'm sorry. 16 is holiday.
All right, 17th.
Wednesday. Duly obliged.
Obliged.
Part 2, item number 18. Item number 19.
Your Lordship, my senior Silaram Zawa, senior advocate, is currently on sick leave, so if the matter may be listed next week.
You're for respondent.
Yes, my Lord.
Who is for petitioner? Earlier somebody appeared. It was called out before. This is called up. This is the timing matter, isn't it? Oh, this is part 2.
That is item number 5 of part 1. Timing matter is item number 5 of part 1.
Part 2. Oh, part 2.
No, this is part 2. No, any timing matter left from part 1 list? This is what? This is 19.
That is part 2.
Part 2, 19.
All right. No, what about the timing? None appears. Huh? You are possessed.
Oh,
yes, why did we pass it over?
If I may, my lord, make a submission. The lead counsel, Miss Mary, is indisposed due to physical illness, my lord. If the matter can be reposted next Tuesday, my lord.
All right. Learned counsel for the petitioner. It is submitted that Miss Mary, who is representing the respondents, is indisposed today. Hence, list the matter again on Tuesday.
Obliged, my lord.
Part 2, item number 18. Part 2, item number 19.
Your Lordship,
None appears for the appellant. Learned counsel for the respondent prays for adjournment on ground of preoccupation of learned senior counsel. When do you want?
Your Lordship, next week.
Matter stands adjourned. List again in the next hearing list. Yes.